Hey, good morning, everyone. In Introduction to Law. This is going to be chapter, I think it's 15 at this point, which is Introduction to Criminal Law. It's one of my favorite chapters. I'm still an active criminal defense attorney in Worcester County, well, throughout the entire state, but my office is in Worcester. Um, Most students really love this topic, and sometimes you'll have an elective if you're a legal studies major to take a criminal procedures class over in the Mounts Criminal Justice program. I often recommend that if you're interested in criminal law because it would dovetail nicely with the other courses we take in the legal studies program. But we don't have a specific criminal law class in the legal studies curriculum, and that's why I often refer students over to the criminal justice offerings and criminal procedures. I think the one that's most interesting and most salient for those of you that are going to be paralegals in that area or attorneys. So let's start out the chapter, categories of crime, where it starts off. There are felonies and misdemeanors. I'm not going to hold you to any strict definition, but if you're curious about Massachusetts, a felony is any kind of offense where you can be sentenced to 1 year or more to a state prison. Misdemeanor is a maximum of 2.5 years in the House of Correction, and then sometimes they keep concurrent jurisdiction where there can be penalties up to 5 years in the district court. But generally speaking, what do you need to know for the practical purposes of it? Usually if something stays within the district court, it's punishable by up to 2.5 years in the House of Correction, therefore it's a misdemeanor. If it goes for 1 year or more, it's probably going to go into the Superior Court, and the potential sanction doesn't mean someone can do probation or a split sentence where they don't even actually do much time at all, but where the time will be spent in terms of eligibility could be into one of the state prisons as opposed to the House of Correction. For the purposes of this text, we don't teach for Massachusetts law directly or want to just focus on Massachusetts, just general principle. Felonies are more serious. They're deemed to be more harmful to society, and misdemeanors are less egregious in their nature. Usually, some people, sometimes when you hear of a certain offense, you say, well, that must be a felony, and it turns out to be a misdemeanor. And in the alternative, sometimes you hear something, well, that sounds like a misdemeanor to me, and then you look into it and you find out it's a felony. Well, why do we care? Well, because there's usually much more significant ramifications for felonies, and also it could impact, both for the government and for the defense, the outcomes related to future employment for the defendant, whether or not they will be eligible to participate in certain programs and things of that nature because they have a felony conviction. And also immigration status might be significantly impacted, whether it's a misdemeanor or a felony. Now getting to the elements of a criminal offense, the first major sort of two-prong penumbras that overhang all criminal charges are the actus reus, or the voluntary act, and mens rea, or the mental intent. Actus reus is somewhat easy. It has, I should say easy, it's actually can be quite hard at times, but it's usually it doesn't have too much controversy of it in a day-to-day case because all it requires is the voluntary action of a defendant bringing about the consequences, or of the voluntary admission from doing what they're required to do under the law. So my point about that is, if I have an epileptic seizure and my body starts flailing around and I hit somebody next to me and they saw the blow coming, so to speak, so they were apprehensive of being struck offensively, they were struck offensively, sounds like an assault and a battery. However, actus reus is going to be a problem for the government to prove because I didn't do that with a voluntary act. And I don't know, I think they came up with a few other good examples in the book of where something might be considered to be deemed involuntary versus voluntary. But most of the time it's obvious. The ones that's not obvious, it's usually in a law school exam or a bar exam, is where someone abducts someone's 3-year-old child and they send a video back to the parents saying, I have your child, I will kill your child if you don't go rob Bank of America this Saturday and bring the funds to me at such and such an address. Now, the person arguably does it of their own volition, but is it truly voluntary? That's the kind of debate we get into sometimes about whether or not somebody's acting with their own decision-making processes and control, and that's a big issue sometimes. That's actus reus. Mens reus is the one where we really get into in greater detail because it's usually on a sliding scale. Something can be something what we call a strict liability. You go through a red light, although that's not criminal. Some states it might be criminal. You go through a red light and you didn't do so with any intent whatsoever. You just, you're daydreaming or whatever, or you literally just put on some new red sunglasses things, and or sunglasses that made the light look green to you, or the person next to you that was driving in the passenger seat while you were trying to concentrate on some road signage up ahead told you the light was green, and you went through. You had no specific intent to go through that red light, but you're going to be guilty because you have it doesn't require intent. If you did it, you did it, even though you did it accidentally. And so there's a gradient scale, and the book does do a nice job putting up the model penal code. We didn't sign on to the model penal code in Massachusetts, but it's a great way in which students can learn about elements of crimes and how to analyze and make arguments back and forth whether or not an element has been established. And they do a nice job outlining the different degrees of intent. And the first one they have is negligence, which is the lowest one. Yeah, I didn't mean to hit the other person. Yeah, you weren't driving carefully. That's negligence. Or I didn't mean to, spill my wheelbarrow over on your driveway. He goes, yeah, but you filled it up so high and you only have so much strength, and you knew the thing was wobbling and you still did anyways. And if the statute only required what we call general intent or just a negligence standard, then you would be potentially guilty on the mens rea count. Then the next one is recklessness. That's the willful disregard of other people's safety in light of the circumstances. And it's like an extreme form of negligence. And it's obviously up to the juror or the judge, if it's a judge trial, to determine how far this person's lapse in judgment goes. Is it mere negligence? And then the book doesn't do this, but Massachusetts is negligence, gross negligence, recklessness, wanton disregard. And then the next one is knowledge and purpose. Knowledge is described as, well, they give an example, driving a car known to have unsafe tires, and driving over the speed limit to excess. That's knowledge because you knew about the nature of the underlying consequences that were likely to occur. Then purpose. You intentionally want to bring about the consequences. I go into a store. I was going to say sushi. I don't know who shoplifts sushi, but maybe I would. And I go in and I intentionally grab that sushi and I stick it in my jacket with knowing that I'm going to try to avoid payment at the cashier's kiosk as I run out of the supermarket. That's knowingly doing so. Murder in the first degree requires specific intent. You have to want to bring about the consequences of death, and you're going to be the actor to do it. It's not going to be accidental. If it's accidental, it might not be a type of homicide at all, but it might be something like a manslaughter, or maybe a second offense murder. We'll get into some of those elements in a second. But those are the kinds of things about mental intent that comes up quite a bit. I brought it up a few times in trials of assault and battery. Did somebody really mean to push the other person? Did somebody mean to really throw an object at that other person with the requisite intent? Because assault and battery is a specific intent crime. That's the argument that's often played out by the defense, and the government knows they have to prove it. Sometimes we can bring down a charge from lesser to a lesser included offense. Like murder has assault and battery inherently. I shouldn't say assault, has battery inherently attached into it. That's probably a bad example, but sometimes assault and batteries and other charges are reduced down to other charges that are inherently built with them. Like a robbery has a larceny contained within it. You're taking someone else's property, but the robbery requires, of course, what? Force or threats of violence as an additional one. Maybe they're going to have a hard time proving that element because it's required to get the whole statute satisfied. But sometimes there's sort of think of as scaffolding off of one charge. Some charges have other lesser included charges inherently in there as part of the negotiation process. We sometimes reduce them down to lower charges. We don't get into Massachusetts, but it's principal in the first that basically the main actor in a crime, and then in the second degree is someone that's in a conspiracy. They want to bring about the consequences, but have a lesser role in the behavior, for lack of a better way of saying it. And then we have these what we call Incohaid crimes, although some jurisdictions don't call these ones Incohaid crimes. Accessory after the fact and accessory before the fact. You don't actually take part in the actual criminal behavior, but you kind of help out bringing about the means and the ability of the principal defendant to bring about the act of the criminal behavior. And after the fact is you find out your friend did something and they hit a pedestrian and they come over to your house and say, can I have my car in your garage for a period of time? You didn't commit the assault, hit and run, but you're participating after the fact in a criminal conspiracy to basically cover up the case. Um, I think of those as incoherent crimes, but they're not. Incoherent crimes are the kind of crime where I intend to punch you in the face or back of the head. You don't you don't see me, so there's no assault. I throw a punch, but because I'm so awkward and poor at doing assault batteries, I miss you completely. But say it's witnessed by the police, and they can prove I wasn't doing it jokingly or without the intent to hit, and I was social, but I really was trying to hit you. That's an attempted battery. Attempt to commit a crime is a type of incoherent crime. I go into a bank. I have a note. Give me all your cash. Don't put any die packs in the bag. And I have a gun, and I'm pointing it through my pocket. And then I panic at the last second. The clerk's looking at me, and I'm looking at them, and I just run out. I didn't do a bank robbery. I did an attempted bank robbery. That's called an incoherent crime. Um, I guess it's nice to know the vocabulary. I don't know how critical it is in the big picture things. That relates also to the conspiracy to commit a crime. Conspiracy is the plan. Like if me and three of my friends get a bunch of drugs together, I might not be actually selling them on the street, but if I was part of the plan and implementation of the overt operation, that's conspiracy to commit crime. They might not actually prove we had possession of the drugs or that we distributed drugs, but they might be able to prove there's a conspiracy. Very difficult if you can't prove the underlying charge against one of the other co-defendants. A very interesting topic for debate is there's three people charged with conspiracy to commit a crime and the underlying crime as well. And then the first two defendants go forward with their trial first. They're both found not guilty. How can the third person be charged with a conspiracy if there's nobody to conspire with if they've been found not guilty? And can you bring in their acquittals as evidence and to show a lack of conspiracy that possibly exists? And I watched a case, and I don't know the answer to be honest with you, but I watched a case one time at the Supreme Court of Massachusetts where they were arguing just that very argument. And I remember one of the justices was skeptical that someone could be convicted of conspiracy if the co-defendant was found not guilty of the conspiracy. There was only two people involved in that conspiracy. And I love this analogy. He goes, isn't it like clapping with one hand? It's not going to work because you have to have the other hand clap against it. I don't know how that case came up, but that judge certainly alluded to that. You can't be convicted of conspiracy unless there's a co-conspirator, and you have to establish that. Like everything else, you always look at the statutes. You always look at when people are charged. I do some things kind of on a regular basis, like assault and batteries and drug possession with intent to distribute, different kinds of assaults and batteries, thefts, robberies, things like that. I do quite a bit, so I'm comfortable with the elements. I know what they are, but I still look them up. I always look up the elements because sometimes there is a specific thing that's required in order to prove somebody guilty, and you might not always know them. And so criminal law is almost universally statutory law. It's going to be found in the statute. The government usually does a very good job of outlining whether something's specific intent, the defendant really had to want to bring about the consequences, or is it just general intent like negligence or reckless conduct, or it might spell it out in greater detail like it's gross negligence that's required. And then it'll spell it, first you have to prove this, then you have to prove that, and then you have to prove this, all beyond a reasonable doubt before the defendant can be found not guilty. And that's one of the things I do enjoy about criminal defense. I think it's a clearer rubric than some of the other areas that attorneys and paralegals have to practice in. Crime of intent, miscellaneous crime of solicitation. That's actually fairly big in Worcester. They pick up a lot of, they're called Johns, mostly men trying to solicit women for sex, and they have undercover police officers posing as prostitutes. And the act never gets consummated or anything like that, but the charge is just solicitation. That's another incoherent crime. They're trying to, but it's not going to succeed because they're actually trying to negotiate with the police officers undercover. And then they go felony crimes. Assault and battery is not a felony in Massachusetts, might be in other districts. Assault and battery are two different things. That's why you have the conjunction and. An assault is putting someone in apprehension of an offensive touching. So, you see someone coming up to you and they look really angry, and sure enough, they take a swing at you, but they miss. You were put in apprehension of an offensive touching. You don't have to necessarily be susceptible to an injury from it. It's just an offensive touching that you were aware that was going to occur. If I take a swing at you and you don't see it coming, there's no assault. A battery is the offensive touching, and it has to be intentional. The defendant had to intend to commit an offensive touching against the other person. And then we get into there's an objectivity standard about what is an offensive touching. You're leaving class and I see you left your laptop or your book bag or something like that right next to you, and I tap you on the shoulder, maybe you're very sensitive about being touched in any shape, way, form, and then you try to have me charged with a battery because I offensively touched you. I think there I'd be found not guilty because I didn't have one, I didn't have the intent to offensively touch you, and two, it was objectively unreasonable to think that was an offensive touching. But you can see how you get into really a lot of debate over all these different little details. I remember in law school, the analogy for an assault and battery is, a battery is if Sleeping Beauty was kissed by somebody other than Prince Charming, she didn't know she was kissed by that person, didn't see the apprehension coming, but the kiss she felt and experienced, and if she found it to be offensive, that would be a battery. Wouldn't be assault because her eyes were closed and she was sleeping at the time. Theft, robbery, and larceny, they're all types of larceny kind of case. Theft is the big per number over all of them, but robbery usually requires threats of force or violence in order to effectuate the basically taking of another person's property against them. It's usually on their person. It's forcibly taken or used, again, some kind of weapons brandish or something like that. Threats of violence or actual violence to take it. That's a felony in Massachusetts, certainly. Larceny is just that. You're taking somebody else's property without their consent, and it's for the permanent deprivation of the defendant's ownership. Usually we can prove that by implication. So if somebody comes running by, you're at a Starbucks, you're having a cup of coffee, let me take a sip of mine now. Someone they don't touch you at all, they don't threaten you, they just grab your cell phone that was sitting on the table as you're going to get up a napkin, and they fled the building. I think they met the elements of a larceny. Someone's taking consciously and knowingly. That's the other thing we'll get to about knowing. Imagine if somebody picked up somebody else's phone by accident. Well, that's not a larceny. You have to intend to take the property of another person without consent, and it has to be to permanently deprive the true owner of it. Now, with a phone, it's by implication. The surrounding facts make it objectively reasonable to believe that person's not going to come back and return that phone later on. Now, it's difficult with cars, and I know this troubles a lot of people. I know it troubles the government quite a bit. I have very few people charged with larceny of a motor vehicle. When I have them often, I don't pick the charge, but when they come to me, they're actually charged with unauthorized use of a motor vehicle. Because in order to prove someone wants to permanently deprive the true owner of the object, they usually have to do something to show that kind of intent. Like you steal the car from Worcester and you're a young person and you stay in Worcester joyriding around with a bunch of your other young friends. You don't paint the vehicle, you don't wipe out the VIN number, you don't try to register it in your own name, and you basically park it outside your house. That suggests that you don't really have the permit. It's going to be very difficult for the government to prove permanent intent, which is larceny of a motor vehicle. They often, if they do charge you with, or a defendant with larceny of a motor vehicle, they often reduce it down because of the difficulty of proving that specific intent element of permanently wanting to deny the true owner the rights to the vehicle. But if they do things like bring it to a chop shop or have it painted and the VIN number somehow changed or something like that, now it shows objectively the specific intent of the defendant. And we know burglary in Massachusetts has broken down the statute quite a bit, but burglary is usually trying to enter the dwelling house of another. And we have burglary at night, which is considered more serious because think about it, if you're the victim of a burglary and it's at night, it's considered more, obviously upsetting and dangerous for the occupants of the home. In fact, now they have a charge called home invasion, which is very, very serious. That's when you put the people in fear in home with the intent to do so while they're occupying it. But there's breaking and entering into the nighttime, breaking and entering in the daytime, which are types of burglary cases. And then usually if it's occupied at the time, nighttime, they usually charge the defendant with home invasion. Very, very serious, long sentences often come about if the government can prove that. And then there's increased elements for increased punishment while armed, things like that, because let's face it, it's a much more dangerous situation both for the victims of the offense, but also even for the defendant if you're going to go and break and enter while armed. So I don't always know all the elements by memory, but they come up quite a bit. But a lot of students want to spend a lot of time on is the whole homicide section in the book. A homicide is the wrongful taking of another person's life without just cause, or I don't know where you can consent. Well, I guess in some states there might be consent to assisted suicide or something like that. We don't have that in Massachusetts right now. But the different ones are voluntary and involuntary manslaughter, 0 to 20 years. Why is it 0? Because involuntary manslaughter is basically a general intent or a specific intent. If I kill someone while I'm drunk driving and I was very, very drunk and I was very unsafe to drive on the road and I just veered off into the other lane and I killed somebody, I've taken their life wrongfully. And therefore, it might be charged as something more serious, but often Massachusetts has a special statute called motor vehicle homicide, but it could also be involuntary manslaughter. Now, why is it 0 to 20 years? Because there's so many mitigating circumstances in involuntary manslaughter. Why is it involuntary? I didn't mean to kill the person at all. That's the distinction between voluntary manslaughter and involuntary. Involuntary didn't mean for the victim to die. Voluntary manslaughter is you did intend to kill them, or you had reckless disregard for their preservation of life based upon the nature of the act that you took. So an involuntary, it's an accidental death, but you're responsible because you either were reckless or you were negligent in the behavior, depending on which part of the statute they charge you under. And the reason why it's 0 to 20 is some people really don't, some of you might be more conservative, and I get it, but there are some fact scenarios where one person accidentally caused the death of another, and jail sentence might not really be appropriate. I think of an elderly person who's lived a model life as a citizen, and they're driving down the road, and they shouldn't be on the road anymore, and they hit somebody in the crosswalk and kill them, and they were negligent. They were driving very poorly at the time. Well, that's motor vehicle homicide. That's a type of manslaughter. It's involuntary. They didn't mean to kill the person at a crosswalk. But do you think it's appropriate now to send, an 85-year-old woman to state prison for any length of time? Are they going to be rehabilitated or something? You can see the parameter. Now, others are, what if somebody's out there and they've already had convictions of drinking and driving, and they're drinking under the influence of intoxicating liquors or drugs, and they're doing it again and again and again, and maybe they've hurt people in the past with their drunk driving, and now they killed somebody. Now, jail time seems much more appropriate, especially if their past history of criminal behavior or conduct within a community doesn't merit mitigation. And I'm not saying defense, I mean mitigation of those circumstances. That's why the statute has a lot of discretion for involuntary manslaughter. Now, voluntary manslaughter is you do intend to kill the person, but the sentence in mass, and I'm not testing on mass law, but the sentence mass surprised a lot of people. It's also 0 to 20 years. Why is that? Well, usually the classic case where there probably will be some jail time is the mitigating circumstances that makes it so it's not murder, because you did intend to kill the person, is something called heat of passion, where no reasonable person could be expected to be able to compose their behavior in light of certain triggering factors. And the classic one was, you're deeply in love with your spouse, you had a 10-year marriage, and she or he or they, they're the reason for your life. Everything's clicking on all cylinders, and suddenly music makes sense to you, and now you like to look at the moon because it tells you things. Whatever. It's just a very beautiful romantic relationship in your mind. And it's, I was going to say St. Patrick's Day, but it's Valentine's Day rolls around, and you're going to surprise your significant other by coming home early from work, and you bought, whatever it is the other person likes, flowers, food, whatever, and you're really going to put on the dog and pony show to show your love and commitment to your spouse. And you come through the door, and there's your best friend with your spouse in the midst of having an affair. In that heat of the moment, no reasonable person usually can maintain their composure. They should, and the law mandates that you do. But if you don't, and you end up killing either your spouse or the person your spouse is having an affair with in a heat of rage that has a certain degree of understandability, it might be manslaughter. It's up to the jury to determine whether it's murder in the first degree, second degree, or voluntary manslaughter. You intended to kill the person. Now, some of the factors go in there. Is it still in the heat of passion? What if this person had to go to their basement and open up a safe to get one of the guns, then open up another safe to get some of the ammunition, and then maybe the other couple left, the spouse and the third party left, and you went and tracked them down, and it took you 2 days to find them down at Cape Cod before you killed one or both of them. There would be a very strong argument the cooling off period had occurred, and maybe it's not involuntary manslaughter. No. The other kind of story where how could you possibly not get jail time by intentionally killing another. The story that's classically used is you have a couple that's been married for 65 years. They've had a very long, beautiful marriage. And husband is in the hospital now with terminal cancer, and he's very, very much in pain. And there's no hope of recovery. And everyone knows it. And he is just suffering. And the husband, who's in bed, suffering, may suffer for a long time to come, maybe months, maybe even over a year before, death, natural, the cancer will take hold. And he asks his beloved wife, please, put some morphine in my morphine drip, enough to kill me. And the wife, out of love, does just that. And I'm not arguing whether this is right or wrong with you folks. I'm just trying to tell you the scenario like this. And the husband does, in fact, die. And it's the proximate cause from the morphine that's been put in the IV drip by the wife. Who knows how she got a hold of it? She got a hold of it. She did. Do you really think the wife will be convicted of first-degree murder? She had intent, was specific, was developed beforehand, but is there a significant mitigating circumstance? Still guilty of a crime, and that's voluntary manslaughter. And I would suggest there that maybe jail time would be appropriate. It wouldn't be appropriate. In Massachusetts, the punishment is implemented by the judge after the defendant's convicted of whatever they're convicted of. So that's the difference between voluntary and involuntary. Involuntary never meant to have the death come about, but because of negligent action, like I hear these stories where people do some really stupid stuff with, guns and bow and arrows and shoot the apple off my head kind of a thing, or hit the apple off my head with a bow and arrow, that reckless disregard for, and you kill the other person. That's voluntary manslaughter, and no intent to kill. Involuntary, you do intend to kill, but there's huge mitigating circumstances, usually the heat of passions, the sort of that standard that comes up in that situation. And the other is just mitigation because of the nature of how and why the person took the other person's life. Manslaughter, murder. Massachusetts has two murder. One is first-degree murder. You have to do it intentionally. It has to be premeditated with malice aforethought. What all that means is there has to be at least enough break between the moment. So if somebody gets in an argument and they just kill the other person right in that moment, that's probably not first-degree murder because they didn't have that malice aforethought. They didn't think about it, at least for a few moments before it occurred. It was in the heat of the moment. Might not be involuntary manslaughter, but it's probably more likely not first-degree murder. In Massachusetts, if you can't prove first-degree murder, it is therefore second degree. I don't like the definition of second. It's sort of like a default for the jury. It's not a voluntary manslaughter type of scenario, but they can't prove malice aforethought or extreme atrocity and cruelty in the death. Obviously, usually one goes hand in hand. If someone kills somebody else with extreme atrocity and cruelty, I think you've established also malice aforethought. But the other independently is sometimes a little bit difficult for the government. And sometimes the judge will instruct the jury that you can find the defendant guilty of, voluntary manslaughter, second-degree murder, or first-degree murder if these different kinds of elements have been established or not established, or you can find them not guilty, obviously. And the felony murder rule is one thing I'm not too keen on, but generally speaking, if you're involved with a conspiracy to commit a crime, and during the commission of the crime, somebody dies, your client or you are also going to be charged with murder under this concept called the felony murder rule. It's a bit controversial because think about it. We're all sitting at the kitchen table here tonight. We're going to go rob the 7-Eleven, and I'm going to be the getaway driver. And we all agree no one's going to get hurt. None of the guns that enemy's going to carry are going to be real. And we make a pledge to each other. No one, we're not going to do any kind of violent act. We're thieves. We're not murderers. I'm out in the car. Other two guys go in. One guy panic. He pulls out a real gun. He shoots the clerk. The clerk dies. That's first-degree murder because it's in the commission of a felony. But the question about me is, I'm the getaway driver. I had an agreement. No one was going to get hurt. It was understood that the guns were going to all be fake. And we even had a gun the night before. I didn't know this guy was going to go rogue on me. It doesn't matter. You were in the commission of a felony, a robbery, and a death occurred. And that's where you often hear, when you do hear about people getting commutations of sentences or things of that nature by governors near the tail end of usually their time in office. usually has to do with the felony murder rule, because there's a recognition sometimes after the fact, in the heat of the moment, there's victims, people are upset, they want everybody involved in this to do life in prison without right of parole. I get that, but the felony murder rule, I think, is a bit draconian. I think there should, I don't know, I'm not the legislature, so I don't get to decide. I just think it's a bit, I like to have more discretion with the judges on the nature of what the punishment should be, because there's all kinds of mitigating circumstances sometimes, and sometimes not. But if you pigeonhole everything into types of parameters, I think it's a bit dangerous. We do have, people don't know, in Massachusetts, we do have these laws in the Superior Court that if you become a career criminal, if you commit so many felonies in a certain period of time, you can be sentenced for extremely long periods of time in prison, including life in prison without parole. I'm not a fan of that mandatory minimum sentencing on anything. I'm very progressive on this thing. I think you need to take the case as they come, and some people do deserve a very, very stiff sentence, and sometimes I think other people don't, even though they meet these criteria of having been involved in bad behavior in the past. Model Penal Code, we know rape is a big deal in Massachusetts, as is in every state. Sexual assaults are huge. They occur quite a bit, and they are not trifled with. The penalties for sexual assaults, rape being the most serious, are very, very significant. And there's a lot of trials over this, because there's a lot of controversy over whether it was consensual, what is the meaning of consent, and you have to look at not only what the statute says for what it is to actually rape an individual, but also the case law on what true consent mean. Because now it's big here in Massachusetts. I keep reading article over article. I have a daughter, 2 daughters in college, and I always worry about the date rape drug is very, very big right now. People are saying one minute they were having one drink at some place, the next thing you know, they were passed out somewhere. And there's predators out there doing these really terrible things, and they get punished very, very seriously if you can prove the elements that are required. I don't want to get into all the gory details of what elements of rape are, but you look at the statute, the one that's often contended, it's rarely, it wasn't me, I wasn't there at all. It's usually, it was consensual, and then you have a trial over the nature of consent. And then there's lesser included offenses within rape, like indecent assault and battery. And then we have age disparities: indecent assault and battery under the age of 14, and then indecent assault and battery over the age of 14. And there's more parameters there for sentencing to very, very, I don't want to say light, because none of them are light, but because there's sometimes some mitigating circumstances in those areas. Electronic and media crime, I'm not going to get into that too much. But if it meets the elements, but then there's also sometimes other rights in play, like free speech, that are in contention with that. Bullying, I've been involved in some school committees that are always trying to draft bullying language, and I think it's salutary, and I think it's necessary to send that kind of message out to the school community that bullying won't be tolerated. But I'm also fearful that when someone's charged criminally with bullying or things like that, the statute can be a bit nebulous as to what it actually means. And let's face it, in a free society, under the First Amendment, there's a certain degree of people being allowed to dislike one another, and maybe even being allowed to even make commentary about that without being sanctioned by criminal law. But cross those bridges when we come to them. Cyber punishment, and again, the punishment's usually done statutorily. The statute will say this is what the parameters of the punishment will be, and the judge will have some discretion most of the time within certain parameters. Sometimes it's just minimum mandatory. This is what you get for this kind of crime, and there's no way around it. For example, drinking or driving after being convicted for an OUI, and you lose your license, say, for 45 days, the minimum mandatory, and then you say, no, I'm just not getting caught, I need to get around. And so you're driving, and they find out that, hey, your license is suspended for a conviction of OUI, and you're in that conviction period of the suspension. That's a minimum mandatory of 60 days in prison. Or jail. There's no way around it whatsoever. If that's what you did, you guys have to prove they were driving, that it was in that statutory period during their penalty. So some things don't have a lot of latitude. Others do, and the judge has a lot of discretion. OUI, very few people on their first offense, if there's no accident or injury, and if they have no previous history with the court system, there's sort of a standard disposition. It's the minimum disposition. It's the 45-day loss of license, the 1-year period of probation, they have to take a driver alcohol education program, they have to pay fairly significant fines. Comes out close to $1,000 in between. And there's head injury assessment fees. Different monies go to different organizations to help address some of the tragedies that drunk drivers sometimes contribute to. But that doesn't mean a defendant couldn't get a much longer period of time if their past history was more egregious, not necessarily with OUIs, because there is a second offense OUI that minimum mandatory 60 as a prison sentence, unless they do an alternative sentence, which is 14 days in an inpatient treatment. I'm getting off track, but my point is the judges usually have a lot of play in the way in which a defendant will be treated, depending on a number of factors. We live in a human society, and each case has contextually different outcomes than others. So maybe both defendants are guilty, but the scenarios are very different between both defendants, and they both met the technical elements of the statute. But because of the nature of the offenses themselves and how they behaved within them, and their history with the court and the community and society and their age and what they've done otherwise, plays into that discretion with the judge. The juries do not do any punishment in Massachusetts. Other states, if someone's going to be given a death sentence, for example, versus life in prison without parole, that's up to the jury to determine that. We don't have that in Massachusetts. We don't even have the death penalty in Massachusetts. White collar crime, they put it in white collar crime as things like embezzlement and other crimes usually related to money. Or avoiding the IRS or things of that nature. The penalties there, unless it's very, very egregious, very rarely end up being jail time. And some people try to argue, well, those are the crimes that really harm society much more than possession of drugs for people with dependency issues with drugs. Now, I'm not in the legislature, I don't control it, but there's some degree of truth that white collar crime, they tend to be wealthier people that get involved in it, so they tend to have better counsel. And I think there's a certain degree of expectation that white collar criminals aren't going to need, not that anybody needs it, is the rehabilitative qualities of being incarcerated in a jail. But that's now the common defenses, justifiable or excusable. Yeah, I hit the person. He was assaulting me. It's a self-defense. And self-defense is probably the biggest one in an assault and battery case. And if the defense raised, the assault and battery has to be reasonable to defend themselves for the apprehension of being offensively touched, and it's a big debate through the admission of evidence. Then it's about, you could argue it's involuntary conduct, so therefore the actus reus hasn't been met. Duress, mistake, entrapment. Entrapment doesn't come up too much, but you wouldn't have dealt the drugs unless some undercover law enforcement officer says, hey, I got this really good opportunity. I got some really great coke. I got some buyers for it. All we need you to help out. And you say, well, I don't really do that. It's not my thing. I guess you can make a big score right now. Come on, do it. You didn't have it in your mind already to enter into criminal behavior, but through the law enforcement sting operation, they motivated you to become an actor in criminality. That's the concept of entrapment. Doesn't come up all that much. Insanity defense does come up a lot. I don't like to call it that in Massachusetts. It's called lack of criminal responsibility. I've had 2 trials on that very issue in the past, time is flying, the past decade. One client had dementia, early onset dementia. He looked like a fairly normal middle-aged guy. And then as I started getting into it, I could tell something wasn't quite right. And sure enough, he had very significant cognitive decline because of dementia. I don't know if it was Alzheimer's. I'm not a doctor, but we had doctors examine him, and it turned out he had no idea what he was doing. And then I questioned, he had no intent to do anything wrong. And what he did was he climbed into another person's car out in a parking lot in broad daylight, because the car's unlocked. We just sat in it. Then he just started looking through the glove compartment, looking through different things. To me, it sounded like he was committing a crime. He was looking for some valuable things and stuff. Didn't steal anything but the true owner of the car. Both of these guys, the victim was probably, it's not that funny, but if you experience the process, he was probably 85. My client was probably 80. And the victim sees somebody else sitting in his car in broad daylight looking through his glove compartment. So he starts screaming and yelling, and he starts running as fast as he can over to this car. My client, who's sitting in the passenger side, is like, oh my God, this guy's running at me, screaming and yelling. So he gets that car and starts running, and they both end up running through this wooded area and down through like a swamp. Oh, it's just a bizarre set of facts. And so I told my guy, I says, it sounds like you were doing it and everything like that. And I could tell he just didn't know what I was really talking about. And I said, well, the guy's almost 80. He must have, people that do things like that often have a history of the court. And I get no record whatsoever. I said, something's not right here. And then I started meeting with his family, and they would tell me stories about how he often gets lost, and then the police call up to say, we've got this person who doesn't know who he is or where he is, and you have moments of lucidity where he's well. And in that, I had to go to trial on that, and it's usually a trial of psychiatrists or psychologists, and medical doctors and family and people that know collaterals that can come in and testify that the person doesn't have the ability to comport their behavior to the rules of society, or they don't know right from wrong in the given moment. And the other example I had was a little bit more classic. My client was actually involuntarily committed to a mental institution at the time. He attacked one of the workers in the mental facility. He got charged with assault and battery, and he knew right from wrong, but he can't comport his behavior because of his underlying mental disease. And I was always shocked that in both cases, the district attorney, when I thought it was fairly obvious, and the medical records came in and we had examinations done of the defendant, that he doesn't have the right, he can't voluntarily do things wrong or comport his behavior to society. I'm a big advocate that people with mental illness should be punished for having mental illness, and I'm glad that most states, Massachusetts including, tried to avoid punishing people for behaviors that are derivative of mental problems. They need treatment. They don't need draconian punishments. But the insanity defense does come up sometimes. I don't think it's very popular with the jury, unless it's like a very, very clear case, because what happens if the person's found to be lacking of criminal response, it's not guilty, and people say, well, they did this act, there should be ramifications from it. Well, there's other mechanisms that some people, if they're unsafe to be in society, could be placed in a mental institution, or there could be guardianships put in place to help protect society from their conduct. But the fact is we have that element of mens rea. They have to have the requisite mental intent to commit the crime, or it doesn't come into play. Other defenses are things like license. She had permission to do, I had permission to take my friend's car. I don't know why he's charging me with crime. Or even in the rape category, it was consensual behavior. We were in a free consensual, and there was regret maybe the next day. That's not rape. And so we go into that kind of set of defenses. The classic defense, maybe the person just didn't do it. It's wrongful identity. That's different. We're talking about defenses based upon lacking sort of the elements that didn't exist. One of my, not mine, but one of my friends' OUIs not that long ago, operating under the influence of intoxicating liquor, one of the elements is required that you have to be in a public way, or a way in which the public has a right to be involved. These kids were in one of these 4x4 vehicles, and they were drinking too much, way too much. And so right away we both thought, well, these kids are guilty, we're going to resolve the case. But the reality was they were on the power lines, there's an access road, and it clearly says no trespassing, not allowed. Things, they drove around the gates because there's kind of a pathway there, and so you can't charge them. You can charge them with other things. You can charge them with trespassing. Maybe you can charge them with public disturbing the peace. I don't know, but it's not an OUI. And so oftentimes we look at the elements and break them down. Breaking and entering in the nighttime. You prove that the timeline that the case supposedly happened was in the daytime. Doesn't mean there's not another crime there. It's just not a breaking and entering into the nighttime. Or they didn't break and enter at all. The door was removed from the home for whatever reason. Maybe it's an old barn of a place, and there's no closed door. So you walk in. There's no breaking and entering. It might still be a larceny inside this. That's what they actually call larceny from a building, but it's not a burglary because you didn't open a closed door or break in any way. So I'm getting a little off track there, but I think it's interesting for some students. What's a felony? Difference between actus reus and mens rea. We went over that pretty well. Oh, strict liability crimes. No intent is needed whatsoever there. If you failed to do something, or you did something without any knowledge of any trying to do anything wrong, you're still potentially guilty. That's like going, you're not supposed to do certain things. You didn't know. I didn't know. What was the thing? The one I was talking about recently with a friend of mine. I kind of knew, but I sort of forgot. I didn't realize I can't talk on my phone while I'm driving on the road. Hands-free device thing in Massachusetts. And that's strict liability. Lack of knowledge about the law doesn't mean you can't do it. You can't be found criminally responsible. There's not too many strict liability cases or types of statutes, but there's enough that you have to be aware that sometimes it doesn't require intent at all. Incohaid Crimes, over that. Theft and robbery. Homicide, how they differentiated. Pretty much it. Great chapter, important stuff. But the next chapter we'll talk about the procedures and the steps to go through. Hopefully I'll have that up in a day or two. Otherwise, don't be afraid to, if I kind of skip over things and just hit what I think are the meat and potatoes of a chapter, but you think something else is very important to talk about, don't ever be afraid to reach out. I'll be glad to talk with you. Be well.